Hi, this is your instructor, Brian Craig. Welcome to the Unit 1 lecture in LA240, Legal Writing 1. In this unit, we'll be talking about the writing process for effective legal writing, corresponding with Chapter 10 in your course text. In terms of the writing process, there are several different stages. One is what's called the pre-writing stage with legal writing. So in this stage, you should organize, research, and analyze the assignment. So one thing is, to consider is asking follow-up questions with whoever assigns you the assignment. Ask follow-up questions if necessary. Is it clearly understood? What type of document? Who is the audience? Is this an internal memo? Are you writing a brief to the court? Is it a demand letter to opposing parties? So you have to think about who your audience is, what the purpose. Also think about time constraints. When is it due? What is the length, format? Also think about the organization in terms of the structure, framework of the document. It really kind of depends. If you're doing an inter-office legal memo, if you're doing a complaint, if you're doing a demand letter. So I really find it helpful with any writing is using an outline. Outlining is really helpful. Helps you organize your thoughts instead of just kind of rambling on. And then one thing is you can use a really basic outline and then use a more expanded outline. So I'll start off with a really basic outline and then use a more expanded outline. And then you integrate your research analysis into your outline while conducting your research analysis. So for example, if you have your first issue, let's say it's an inter-office memo, you have your first issue and then you have specific research, a case or statute underneath that. For an expanded outline for a legal office memo, you'll have the issue and framing the issues. Usually I try to use it as a yes or no question. List all ideas, formulations of the issue, statements of facts. So here you'll identify all the relevant facts. And then you'll have the analysis or application. So this is where you can have the rule of law, whether it's a case or statute, regulation, constitutional provision, whatever it might be, or maybe a combination of those. And then apply that to the facts of the case. For cases, this is going to be probably the most common source of a law that you'll use will be case law. So you have court interpretation of the rule. You'll give the name and citation of the case, brief summary of the facts, showing that the case is on point, the rule, principle, reasoning applied by the court. And also look, the specific, not just the black letter rule, but what are the relevant facts in that case and how you can analogize the holding in that case to the facts of your current case, or how you would be able to distinguish that case to the facts of your client's case. Counter analysis, you always want to think about what are the counter arguments. Conflicting case law, what is the opposing party going to bring up? Are there cases, is there law that goes against you? If so, how can you maybe distinguish that line of reasoning according to the facts of the particular case? Maybe a potential counter argument, maybe it might be a persuasive authority from a sister jurisdiction. Maybe you have had a situation of a split authority between two different circuits. So you might have, always think about what are the potential arguments for the opposing party. And in conclusion, you summarize the analysis. So that's kind of just with your expanded outline. And then once you have that pre-writing stage, then you move on to the writing stage, and we'll be talking more about that. So, but that's just a short overview for that. And then once you get to the writing stage, then you'll assemble your research analysis into a written product where you have drafting, prepare the writing location, materials, work at the best work time, write at the best work time, and limit your interruptions. You try to set some time to be able to work on the project. And again, it's going to depend on the facts and your specific situation, how long you have. Begin with the easiest part of the assignment. Maybe it's just a jurisdictional question at first as a threshold question, and then as you get into more complicated parts, so maybe jurisdiction, maybe that might be stipulated. So maybe just briefly address that, begin with that, and then maybe move on to the more challenging parts. Don't try to make up the first draft of the final draft. You go through multiple different revisions. Legal writing is a process. You can't just do it the first time uh, out of the chute. And then write only when you're prepared. You want to do your research first, do your outlining, do an expanded outline before you start jumping into your actual writing. If you're stuck, go to another part of the assignment and establish a timetable. Limit a. I like to break it up into different parts when I'm doing writing. And think about what your deadline is. Revision is a really important part of the legal writing process, and editing, revising, going through. Is it well organized? Is the writing clear? Does it make sense? Is it concise? Can extra words be eliminated? A lot of times in revising, it's not so much of adding things, but taking things out, or maybe restructuring, maybe using more active voice, active verbs as opposed to passive voice, uh, limiting your use of pronouns, things like that. Is the writing complete? Are all aspects of the assignment covered? Are legal authorities correctly cited? And are the authorities that you're using, are they still good law? You always want to make sure that the authorities, maybe you've been working on the project for maybe 2 weeks, there might have been a new case that came along, so you always want to use Keysight or Shepherds to make sure that your authorities are still uh, up to date, haven't been reversed or overruled, and that they're correctly cited. And then also just the technical aspect of proper spelling, grammar, punctuation, things like that. So go through multiple times, read out loud, print out a hard copy. I find helpful. Maybe ask a colleague to also review the document. Don't just rely exclusively on spell check and grammar check. I've seen lots of things like breach a contract instead of breach a contract, or compliant versus complaint, which are words in the English language. So it can be a tool. I'd spell check and grammar check, but don't exclusively rely on that. So that's just a short overview of the different stages of legal writing. If you have any questions, please let me know.